What is environmental due diligence for inherited commercial property? Environmental due diligence is the risk check heirs should do before selling inherited commercial or industrial real estate, especially when the property has a history of chemicals, petroleum, solvents, underground storage tanks, or industrial use. A building can look fine while the land history still creates a sale problem. Gas stations, dry cleaners, auto repair shops, manufacturing tenants, warehouses, and industrial users can leave issues that are not visible from the street. The federal law heirs need to know is surclu, also called superfund. Surclu can make a current owner responsible for cleanup even if that owner did not cause the contamination, but surclu also has landowner liability protections, including protections for innocent landowners, contiguous property owners, and bona fide prospective purchasers. Those protections depend on due diligence, acquisition history, and continuing obligations. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes City Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, environmental, or real estate advice. Before selling inherited property, speak with a CPA, and when probate, trust administration, or contamination risk is involved, speak with an estate attorney and an environmental attorney. Can heirs be liable for contamination they did not cause? Yes, surclu can create owner-based cleanup liability, but heirs should have an environmental attorney review whether a landowner. Protection, a state-specific fact pattern, or state law issue changes the risk. Does inherited commercial property need a Phase 1 environmental site assessment? Inherited commercial property often needs a Phase 1 environmental site assessment before sale when the property has risky current or prior uses, when a buyer or lender requires it, or when the estate wants to understand environmental risk before marketing. A Phase 1 ESA is the standard first step. When legal or lender reliance matters, it should generally be performed by a qualified environmental professional under ASTM E 1527-21 and the EPA's All Appropriate Inquiries Rule. All Appropriate Inquiries, or AAI, is the process of evaluating a property's environmental conditions and potential contamination liability. For heirs, the goal is simple: find the environmental issue before the buyer, lender, or closing deadline finds it for you. Does every inherited commercial property need a Phase 1 ESA? Not always. A low-risk office building may need a lighter review, but a property with petroleum, solvents, dry cleaning, manufacturing, auto repair, industrial, or underground tank history should be treated as higher risk. What does a Phase 1 environmental site assessment include? A Phase 1 ESA is a records, history, and inspection review. It usually does not test soil, groundwater, vapor, or building materials. A typical Phase 1 looks at ownership history, prior uses, environmental databases, historical maps, aerial photos, regulatory records, a physical site inspection, and interviews with people familiar with the property. The main output is whether the environmental professional identifies a recognized environmental condition, often called a REC. A REC means there is evidence of a release, likely release, or material threat of release of hazardous substances or petroleum products on, at, in, or from the property. What happens if a Phase 1 finds a recognized environmental condition? The next step may be a Phase 2 environmental site assessment, which can include sampling. It may also lead to attorney review, buyer disclosure strategy, pricing adjustments, cleanup estimates, or more negotiation before closing. When is environmental due diligence especially important for heirs? Environmental due diligence is especially important when the inherited property has a history involving petroleum, solvents, chemicals, or industrial operations. The classic higher-risk examples are gas stations, dry cleaners, auto repair shops, manufacturing facilities, printing operations, machine shops, warehouses with chemical storage, and properties with known or suspected underground storage tanks. Property next to contaminated land can also raise questions, even if the inherited parcel was not the original source. For heirs, this can become a timing problem. A buyer may ask for a Phase 1 during due diligence. A lender may ask for environmental screening before funding. A legal team may need time to evaluate disclosures, indemnities, or cleanup obligations. If the estate is in probate or trust administration, delays can ripple through the entire sale. What should a personal representative, executor, or trustee do first? Before listing a higher-risk property, ask the broker and attorney whether a Phase 1 ESA should be ordered up front, so pricing, buyer strategy, and timeline are based on known facts instead of hope. What changed with PFAS, PFOA, and PFOS? As of July 8, 2024, PFOA and PFOS, including their salts and structural isomers, are CERCLA hazardous substances. That makes PFAS part of the environmental due diligence conversation for some inherited commercial and industrial properties. PFAS stands for per- and polyfluoroalkyl substances. The point is not that every inherited property has a PFAS problem. The point is that sites with industrial history, manufacturing history, firefighting foam use, plating, textiles, paper coating, landfill activity, or similar operations may deserve a closer PFAS question. Does PFAS matter when selling inherited commercial property? It can, especially when the property history points toward PFOA, PFOS, or other PFAS risk. A standard Phase 1 may address PFOA and PFOS where relevant, but broader PFAS review may require an expanded scope depending on the consultant, property use, buyer, lender, and state law. What should heirs do before listing or selling? Heirs should answer the environmental question before the property is fully marketed, before accepting an offer, and before the sale timeline is controlled by a buyer's due diligence deadline. Start by gathering old leases, tenant records, property files, permits, maintenance records, tank records, prior environmental reports, insurance materials, and any notices from state or local agencies. Then ask a qualified commercial broker, environmental consultant, and attorney what level of review fits the property. Should heirs wait for the buyer to discover the issue? Usually no. Waiting can reduce leverage, create surprise delays, and make the buyer wonder what else the family does not know. Finding the issue early gives the estate trustee or heirs more control. What is the main takeaway for heirs? The main takeaway is that inherited commercial property should be checked for environmental risk before sale, especially when the site has a history of petroleum, solvents, chemicals, industrial use, or PFAS-related operations. A Phase 1. Environmental site assessment is often the right first move because it gives heirs, brokers, attorneys, buyers, and lenders a shared starting point. It does not solve every issue, and it is not a substitute for legal advice, but it can prevent an avoidable surprise from becoming the reason a good sale stalls. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free. You do not need to become an environmental expert before selling inherited commercial property. But you do need to ask the environmental question early because in commercial real estate, what happened on the land can matter as much as what the building looks like today.